There's news, there's an update in the Satanic Temple lawsuit. In fact, there was already an update by the time I published the last story a few days ago. Here's the court docket. Let's start there. Apparently on March 31st, because this is out of order. I don't know if you see this here, but plaintiff did motion for a temporary restraining order. The response to the temporary restraining order was due April 11th, which was then filed, of course. And then they held a hearing on the 20th. And this was on the temporary restraining order, which has not yet been granted or denied because there have been happenings. After the April 20th hearing, this letter was filed by the Saucon Valley School District attorneys. Dear Judge Gallagher, please be advised that consistent with Superintendent Jamie Vlasity's testimony at the April 20th hearing, the Saucon Valley School Board approved revised versions of Policy 707. As the board made additional editorial changes to these documents at last night's meeting, we have not received the final copies. We intend to file all 3 documents as soon as we receive them, and they did file that later that day. So this is the new policy revised April 25th. And I thought this would be a good opportunity to show you something that us attorneys do, and you can do too. When you're looking at a document that's been revised and you don't know what the changes have been, you can run a compare report. Now, I think this is a paid feature of Acrobat, but that's what this allows me to do. So the compare report is not perfect, but if you look at what's on the left versus what's on the right, and there's like lines that go between them to show where things connect and where they've been added. You can go through here and you can see some things have been changed. Like paragraph 3 here used to say, when advertising or promoting activities, individuals and community groups shall clearly communicate that the activities are not being sponsored by the school district. And then now in the new document, they have categorized different groups. So group 1, 2, 3, 4, 5. That definition is, I think, up here. Group 1 is board approved things. Group 2 is school affiliated organizations. And then group 3, 4, and 5 are not school affiliated organizations. So those groups shall clearly and prominently communicate that the activities are not being sponsored by the district, including such language in all advertisements and proposed material. Quote, this event/activity is not approved or sponsored by the Saucon Valley School District or its board of directors. And then they also changed the time. Now these activities for groups 2, 3, 4, or 5 shall start no earlier than 6 p.m., I guess, so that there's some sort of disconnect between the school day and the activity then. So it's harder to say that this is a school-related activity when it's not supposed to be. And this was put out after Jamie Vlasity, superintendent of the school, testified, doubled down, even tripled down on her belief that the Satanic Temple's application and the fact that it lacked that, well, okay, so wait a second. We know that she asserted that it lacked that disclaimer language when the official form actually did not. And it seemed like it was community posts. It was posts not made by the Satanic Temple that didn't have a disclaimer. And why would they? You know, when Leonard French, the community member, wants to tell his community about something he learned about as a member of the community, not something I'm running, not my event, I go, hey, did you hear about this event? I don't go, hey, did you hear about this event? By the way, this event is not sponsored by Saucon Valley School District. No, of course not. So that's what it looked like Superintendent Vlasity was using as a pretext, that some community members had posted the thing and not included the disclaimer with the text of their posts. And then, of course, there was a threat against the school district by someone completely unrelated to the Satanic Temple and the After School Satan Club. And then she used that as a pretext, as a disruption. So the judge also asked for further briefing no later than Friday, April 28th. Ooh, that should already be on the docket then. Briefing shall be filed whether defendants' purported basis for rescinding approval for plaintiff to rent district facilities satisfies the substantial disruption test in Tinker. If you are not familiar with Tinker v. Des Moines Independent School District, Community School District, it's the case that established the limits on the First Amendment for students in a public school, like in a grade school. So minor children. And what are they allowed to do? Say, if I wear an offensive T-shirt to school, don't I have the right to free speech? Aren't I protected from government action? The public school is the government. Therefore, the public school, the government can't infringe my right to wear an offensive T-shirt. Well, that's where this substantial disruption test comes from. If the speech directly causes a substantial disruption, then it can be limited. So you can ask somebody to take the shirt off, turn it inside out, put a different shirt on, that kind of thing. If it doesn't cause a substantial disruption, then you have the freedom of speech. So I don't believe that the Satanic Temple's application is what caused the disruption. I think the disruption was caused by others overreacting to the Satanic Temple's right to apply for a room. Now, let's take a look at that court docket and see if there's anything from the 28th. There is. We have the response in opposition and the response in support. Let's take a look at them. I'll buy them for everyone. Let me just not give you my username and password. We'll start with Saucon Valley's first. This is Saucon Valley's supplemental brief in opposition of the motion for a temporary restraining order or preliminary injunction. And they're going to address Tinker v. Des Moines. Exactly how did this application cause a substantial disruption, such that the TST was denied their after-school Satan Club? The district's rescission, writes the district, of TST's approval is supported by the well-established principle of Tinker v. Des Moines, that the special characteristics of a school environment allow a state-run school to prohibit expressive actions that might reasonably lead school authorities to forecast substantial disruption of or material interference with school activities. School officials may regulate speech or action that intrudes upon the work of the schools or the rights of other students. The Supreme Court unequivocally stated that the associational activities need not be tolerated where they infringe reasonable campus rules, interrupt classes, or substantially interfere with the opportunity of other students to obtain an education. So, then the question is, how is she going to link TST's application to some kind of substantial disruption or an inability to follow the rules, especially rules that were enforced equally against everybody and not rules that were not enforced equally against everybody? Let's take a look. When the school district superintendent decided to rescind TST's facility use approval, she and the district were still in the midst of an actual ongoing disturbance, stoked, if not outright caused, by TST's violations of the advertising limitation in Policy 707. The district received a credible threat of violence from out of state from an individual who threatened to come up and shoot everyone. So she's really trying to connect the TST's application with these threats. And I think this is super disingenuous. Like, would she be okay with everyone connecting any violence that came from someone who practices the Christian faith to all Christians? Like, would she deny the Good News Club because some Christians commit violence? No, she wouldn't. Of course she wouldn't. She didn't. She approved it. So now, because someone else, not from TST, committed an act of, a threat of violence, she's using that as pretext, as a reason. Oh, look, I want to do this thing, and then I can just say it's this reason. The threat led Superintendent Vlasidy to institute an abrupt emergency evacuation, etc., etc., etc. Now, that was in February 20th and 21st, not the March 8th when they were meeting. TST's actions here and the ensuing disruption, which lasted an in-school week, was a more significant threat of a potentially violent disturbance than in other cases that were approved. In Dariano, the Ninth Circuit held that the assistant principal's decision to ask 3 students to turn their shirts inside out, remove them, or leave the school for an entire day with an excused absence was allowed. Yes, so that's what I was talking about, like turning your shirts inside out, because the shirts were causing a direct disturbance. not because somebody else made a threat to the school based on the students' shirts. Recognizing that limited speech because of reactions to it could give rise to concerns about a heckler's veto, the Dariano court emphasized that the special characteristics of a school environment compelled it to make a distinction between threats of violence in non-school settings and those in school settings. It reasoned in the school context, this crucial distinction is the nature of the speech, not the source of it. Because Tinker and its progeny do not distinguish between substantial disruption caused by the speaker and substantial disruption caused by the reactions of onlookers or a combination of circumstances. Plaintiffs note that most disruptions occurred only because of wrongful behavior of third parties and that no plaintiffs participated in these activities. This argument might be effective outside the school context, but it ignores the special characteristics of the school environment, and that the court had not found case law holding that school officials' ability to limit disruptive expression depends on the blameworthiness of the speaker. I don't know, then how do you accommodate the heckler's veto? The requirement or the prohibition against a heckler's veto. So what you're saying in that paragraph, Superintendent Vlasidy and Saucon Valley School District, is that the Satanic Temple can't have a club, they can't have the equal protection of the laws because some third party threatens the school whenever they do. So this minority party can't have rights, totally peaceful, nonviolent rights, because someone who doesn't like them makes a threat every time. That's what you're saying is allowed here. And you're also saying that this is about a after-school activity. So this didn't disrupt school day activities. This disrupted after-school activities, or rather, this was an after-school activity that you're saying disrupted day school activities. So I don't. This is a really thin connection here, but we'll see what the judge has to say about that. I bet you the judge is going to try and call it a tie. I know such a thing doesn't really exist, but they did change the policy. So you see why they changed the policy here, because they also feel like they're going to lose this one. The decision to rescind TST's approval to rent district facilities as a result of those violations was a reasonable response to the actual material substantial disruption. Okay, we get it. You're trying to connect the TST's application with the threats of violence, and that it doesn't matter whether TST had anything to do with the threats of violence, TST should be the one that suffers. Let's see what the ACLU has to say. The district contends that it rescinded approval for the use of facilities because TST failed to comply with the advertising provision, not because the district feared disruption by opponents of TST's viewpoint. The district took this position because it is well aware that excluding TST's after-school Satan Club from the after-school facilities forum based on a fear that those opposed to the club's viewpoint will cause a substantial disruption would result in an unconstitutional heckler's veto. Dueling citations here, so now they're saying the First Amendment does not permit the so-called heckler's veto, allowing the public, with the government's help, to shout down unpopular ideas that stir anger. Fear that objectors to a speaker's viewpoint will cause disruption is never permissible as a reason to exclude that speaker from a forum to which it would otherwise be entitled access. It is the district's burden to show that its actions here are viewpoint neutral. By the way, that's a Bible Believers versus Wayne County. So again, we're citing two cases where Christians were allowed to have their after-school clubs and things. And here's one where, because they're not Christian, they're not allowed to have it. Another case, Marshall v. Amuso, while the moving party typically faces the burden to establish the likelihood of success, so that's a irreparable injury, that's an injunction standard. In the First Amendment cases, the initial burden is flipped. The evidence produced by plaintiff, and indeed Superintendent Vlasidy's own testimony, makes clear that the district has not met this burden. Neither the Supreme Court's in Tinker nor the Ninth Circuit's holding in Dariano change the district's burden in this case, or otherwise alter the legal analysis relating to viewpoint discrimination in a forum. First, the Supreme Court has declined to apply Tinker in cases involving unequal access to a school district's facilities. So yeah, remember what I said about how this was an after-school club and this was access to the district's buildings? That's not the same thing as a student disrupting classes. This was not a student disrupting classes. This was a community entity renting a facility, and everybody's allowed to rent facilities. Consistent with its view that Tinker is inappropriate or inopposite in such cases, the court has rejected the argument that a school district may engage in viewpoint discrimination with respect to its facilities use forum, even where officials might reasonably fear that allowing a controversial religious speaker access would cause public unrest or violence. Second, Tinker and Dariano govern disruption or potential disruption resulting from speech made by students during the school day. They do not apply to speech made by adults in private organizations outside of the school day, or part of an expressive forum, or in connection with events that are not school-sponsored. Moreover, Dariano notwithstanding, the Supreme Court and other federal courts have cast doubt on the application of Tinker to substantiate a heckler's veto. And remember, Dariano's from the West Coast, not from Pennsylvania. And finally, the district has not demonstrated that rescinding approval of TST's application and denying the group access to district facilities is necessary to prevent future disruption. Remember, this is going to be a strict scrutiny evaluation. It must be narrowly tailored to effectuate a necessary government goal. The district has blamed the disruption to its operations on the fact that TST failed to properly make clear that the ASSC is not a district-sponsored activity, but there can be no question now that everyone knows that the district does not sponsor the ASSC. And to the extent that any doubt were to remain about this fact, plaintiff has offered to include on its permission slip and promotional materials whatever disclaimer the district may want. Although the First Amendment may allow the government to impose content restrictions on speech in a non-public forum to prevent disruption caused by the discussion of topics that may inflame passions, it does not permit the government to allow the expression of one particular viewpoint on a controversial topic, while restricting another, because no matter what kind of property is at issue, viewpoint discrimination is out of bounds, another Third Circuit Court of Appeals case. Indeed, courts should exercise caution even when faced with such a content-based restriction, because it conflicts with the core purposes of the First Amendment. It invites a heckler's veto by signaling that the government will suppress unpopular speech if the public behaves badly, and it's hard for officials to apply these standards objectively, and harder still for courts to assess whether they have done so. In this case, the district has not excluded all religious speech from the forum due to the risk of disruption. It has only excluded TST's religious speech. That is an impermissible viewpoint-based restriction. More than a decade after issuing its decision in Tinker, the Supreme Court made clear that when it comes to access to school facilities, the court's forum analysis governs. In the Perry case, a teachers' union challenged a public school district's denial of access to its male facilities. Applying its forum jurisprudence, so public forum, the court ruled that the male facilities were a non-public forum, in part because there was no indication in the record that the school mailboxes and inter-school delivery system were open for use by the general public. Given this determination and the court's opinion that no viewpoint discrimination had occurred, the court ruled in favor of the district. In reaching this conclusion, the court rebuffed Justice Brennan's dissent as improperly minimizing the importance of a public forum analysis in the case. The court explained that Justice Brennan had erred in putting aside the court's decisions holding that not all public property is a public forum, and pointing out that in any event, most of the previous cases relied on by Justice Brennan were fully consistent with our approach to and resolution of this case, because they involved restricting access to public forums. However, the court made clear that several cases cited by the dissent, including Tinker, were inopposite. Tinker did not involve the validity of an unequal access policy, but instead an unequivocal attempt to prevent students from expressing their viewpoint on a political issue. And two other cases did not concern access to government property. To that end, neither the majority nor concurring opinions even nominally invoked Tinker. In Lamb's Chapel, there, the court held that a school district which had opened its facilities for after-school use by a wide variety of private organizations for social, civic, and recreational purposes could not discriminate against a local evangelical church that sought access for the purpose of screening a film series regarding family values and child rearing. The school district argued that it had justifiably denied use of its property to a radical church for the purpose of proselytizing, since to do so would lead to threats of public unrest and even violence. But the court rejected the district's proffered excuse, holding that there is nothing in the record to support such a justification, which in any event would be difficult to defend as a reason to deny the presentation of a religious point of view about a subject the district otherwise opens to discussion on district property. In ruling for the church, the court applied its public forum jurisprudence, not Tinker. In its brief, the district elaborated on its concern. It is eminently reasonable to expect problems to arise if a particular religious or political group is granted access to a public school building. Such problems clearly would not be limited to radical religious groups. Given the wide range of existing religious beliefs and that certain beliefs are inherently offensive to others, sometimes violently so, it is sensible to anticipate that a certain group's use of facilities in a particular religious or ethnic community would give rise to a volatile and destructive situation. Likewise, in Good News Club versus Milford Central School, remember, in this case, the Saucon Valley School District has allowed the Good News Club to meet, and the After School Satan Club is the one that's been denied, even though the Good News Club did not have these pretextual disclaimers that Jamie Velocity is citing. The court relied on its forum case law to rule in favor of the Good News Club, who sought access to a public school district's facilities use forum for the purposes of holding after-school meetings. At oral argument, Justice Scalia characterized the district's argument as allowing a heckler's veto, that if people don't like what the school is doing and are unhappy about it, that's a reason for excluding religion. Holding for the club. So, in favor of the Good News Club. The court subsequently made clear that the district could not justify excluding the club from the school's facilities based on a modified heckler's veto. As in Lamb's Chapel, the court's opinion included no mention of Tinker, nor did the concurring or dissenting opinions. Tinker does not apply to speech by non-students at events and activities not sponsored by the district. That the Supreme Court has not applied Tinker to private organizations' claims of wrongful exclusion from school districts' forums for the use of the facilities is not surprising. As the U.S. Court of Appeals for the Third Circuit has explained, Tinker and its progeny plainly apply to student expression. Forum analysis, they keep calling it forum analysis. I get that that's the name for it, but I really think it should be called public forum analysis. But it is public/private forum analysis, not public, non-public. Generally applies to the rights of outsiders who attempt to speak in our public schools. The substantial disruption test in Tinker and its progeny provides a narrow exception to the First Amendment, permitting public schools to restrict student speech based on the special characteristics of the school environment. Neither the speaker nor the forum at issue here bear the characteristics to which Tinker's limited restriction on student speech applies. In Perry, the speaker was the teachers' union, in Lamb's Chapel, the church, and in Good News Club, the club. Here, the speaker is TST, a private religious organization operated by adults. And like the speakers in these other cases, TST seeks access to district facilities to engage in speech. Here, as in Lamb's Chapel, Perry, and Good News Club, as part of an expressive forum opened by the district for non-school groups that wish to hold meetings and other activities, not sponsored by the district after the school day ends. Applying Tinker's substantial disruption test to speech by a private organization in this context would be a novel expansion or a new expansion of the government's authority to exclude speech by disfavored groups. In other words, new law that the district court cannot make. The district court needs to defer to the appeals courts and the Supreme Court, and those courts are allowed to rule on new law or expansions of law or modifications of interpretations of law, not the district court. Indeed, as far as plaintiff is aware, Tinker's substantial disruption standard has never been applied to speech by non-students seeking access to a public or non-public forum that operates outside of the school day and does not involve school-sponsored activities. For the same reason, Dariano is likewise inapplicable to the forum at issue in this case. Dariano involved public school students who wore T-shirts to school that school officials reasonably believed would cause a material and substantial disruption of the school day. The Ninth Circuit specifically noted the relevance of the setting where the speech took place at school during the school day to the school's authority to censor speech. Indeed, notwithstanding Dariano, some federal appellate courts have been very circumspect about using Tinker to effectuate a heckler's veto of students' speech based on other students' reactions. See Zemanek versus Indian Prairie School District, noting that concluding that other students' harassment of Zemanek because of their disapproval of her "Be Happy, Not Gay" t-shirt is not a permissible ground for banning it. Holloman v. Harland, interpreting Tinker as endorsing an anti-heckler's veto principle and holding that while the same constitutional standards do not apply in public schools as on public streets, we cannot afford students less constitutional protection simply because their peers might illegally express disagreement through violence instead of reason. But see Taylor v. Roswell Independent School District. Plaintiffs note that most disruptions occurred only because of the wrongful behavior of third parties, and that no plaintiffs participated in these activities. This argument might be effective outside the school context, but it ignores the special characteristics of the school environment. And then there's an Easton area school district, which is actually in Saucon Valley's area, in the competitive area of the region. The court has not determined the precise interplay between the anti-heckler's veto principle present elsewhere in free speech doctrine and Tinker's substantial disruption standards in public schools. So that question still needs to be fleshed out, that legal issue of where is the line between a student's free speech in school and the heckler's veto, when other students, opposition, bullies, whatever, when they react poorly or violently or disruptively. So I wear a t-shirt that says "Be Happy, Not Gay," and the school students, other students react poorly because of it. Is that my problem? And that's what that paragraph was about. And the Supreme Court's recent ruling in Mahoney casts further doubt on schools' authority to censor students' unpopular or controversial speech based on the reactions of other students at school, especially when the speech occurs off campus. Mahoney explained that schools have a diminished interest in regulating students' unpopular expression to avoid the risk that other students will cause a disruption in reaction to speech. As Justice Alito notes in his concurring opinion, when speech causes a material and substantial disruption at school, the school may suppress the disruption, but it may not punish the off-campus speech that prompted other students to engage in misconduct. Rather, if listeners riot because they find speech offensive, schools should punish the rioters, not the speaker. Duh. In other words, the hecklers don't get the veto. And then Accord Kennedy versus Bremerton School District, holding that under the First Amendment, protected speech or religious exercise does not readily give way to a heckler's veto. In any event, the ACLU continues, Tinker certainly has not been applied to authorize restrictions on speech by non-students in a public or non-public forum that operates outside of the school day and does not involve school-sponsored activities based on the reactions of those who may object to the speech. On the contrary, courts have steadfastly refused to allow the government to exclude speakers from forums based on opponents' reaction to their viewpoints. See Forsyth County versus the Nationalist Movement. Speech cannot be financially burdened, any more than it can be punished or banned simply because it might offend a hostile mob. Back to the Bible Believers case. The Supreme Court has repeatedly affirmed the principle that constitutional rights may not be denied simply because of hostility to their assertion or exercise. The Marshall case, prohibiting speech because it disparages or offends others, is impermissible viewpoint discrimination. Maddle v. Tam, noting the court's rulings time and again that the public expression of ideas may not be prohibited merely because the ideas themselves are offensive to some of their hearers. Justice Kennedy concurring, government may not insulate a law from charges of viewpoint discrimination by tying censorship to the reaction of the speaker's audience. As the Supreme Court has long recognized, participants in an orderly demonstration in a public place are not chargeable with the danger unprovoked except by the fact of constitutionally protected demonstration itself that their critics might react with disorder or violence. Even if Tinker and Dariano somehow applied here, the district's rescission of approval and refusal to let the ASSC convene on the same terms as the Good News Club was not necessary to prevent future substantial disruptions. In Dariano, there was a history of violence among students, some gang-related and some drawn along racial lines. Over the course of the prior 6 years, the high school's principal observed at least 30 fights on campus, both between gangs and between Caucasian and Hispanic students, and a police officer was stationed on campus every day to ensure safety on school grounds. These tensions between students erupted on Cinco de Mayo in 2009 and caused a serious disruption, including an incident involving a student wearing a t-shirt bearing the American flag. On Cinco de Mayo in 2010, the same student again wore a t-shirt with the American flag along with a group of other students. Several students informed the principal that tensions were again rising, and the principal, reasonably fearful of an imminent altercation, instructed students to turn their shirts inside out. Those who did not were sent home. There is no similar extended history of violence here. There is no imminent threat. The district attributes the disruption of its operations to the fact that people misperceived the ASSC as being sponsored by the district due to TST's alleged failure to include an adequate disclaimer on its permission slip and online advertisement. But the district itself has repeatedly clarified that it does not sponsor the ASSC or any event held by private organizations such as the ASSC and Good News Club that rent school facilities pursuant to Policy 707. No reasonable person could believe otherwise at this point. By the district's own reasoning, then, the danger of a substantial disruption due to people misperceiving the club's sponsorship has passed. Moreover, the district was quickly made aware by law enforcement that the threat it received was not made by a member of the community, but rather by a resident of North Carolina, hundreds of miles away. That man is in police custody, and the district has produced no evidence that other threats remain. Furthermore, if any doubts remain as to the district's sponsorship of the ASSC, TST has offered to include on its permission slip and promotional materials whatever disclaimer the district may want. Given these facts, any fear of disruption that the district may assert is not a valid basis under Tinker for continuing to deny TST access to district facilities. You can see the difference in quality between the district's arguments and the ACLU or TST's arguments. The ACLU was very clear about how Tinker does not apply, whereas the brief from Saucon Valley seemed to not really notice that that issue existed at all. It should be fatal to Saucon Valley's case. Now, the fact that they updated their policy would be a good first start. So they updated their policy. Now they have to apply that policy to everyone. They have to reinstate TST's permission to hold their after-school Satan club. And I have a feeling they're going to owe some kind of damages to the ACLU, to TST, for having denied them under these pretextual and obviously unfairly discriminatory circumstances. Anyway, that's the update in that case. I'll keep bringing you updates as we see them. Let me know what you think of this case in the comments below. And thank you to the supporters that I call out by name, who are Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, Gutbrodj, TechTechPotato, King Aries, and Kyle Siefring. And yeah, well, there's the Blood-Soaked Survivors and Don't Credit This Account are the new ones, right? Yeah. Happy birthday, everyone. Love you all. Bye.